Hi, and welcome back to another episode of NCBA's Coffee Break. I'm Nathan Willner, your host, and we're continuing our conversation with Frank Veneziano. I'm not going to get that, so I'm just going to call you Frank.
You did great, by the way, that time. Well
Well,
done.
thanks. Thanks. Well, I speak to you enough. I should get it, but but we're going to talk to Frank about Replevin and debt collection litigation and some amazing opportunities. So, Frank, great to have you back with us, and thanks for uh, joining me to do a deep dive on this topic.
Yeah, thanks for having me again, Nathan. I enjoy it. I think it's a great topic. I'm very passionate about um, helping auto lenders, get their collateral back, and that's why we're here today. Talk about that.
Yeah. And so, for our listeners that may not be familiar with you, your background, you come from industry.
My gosh, yeah. I hope I don't look my age, but I've spent about 40 years in the debt collection space, working for creditor rights law firm. I cut my teeth for almost 30 years at Weltman Weinberg and Reese, which is a very well known, very well respected creditor rights law firm. I was blessed to grow up at that firm with Bob Weltman and Alan Weinberg and Al Reese, and they really spent a lot of time talking to us about how to be good lawyers, right? How to work files, how to work cases, how to represent clients. And I wouldn't be where I am today, and I wouldn't have the success today without those individuals in that firm. So I'm always very appreciative of what they've did for me and the knowledge they instilled. And I've had some opportunities since I left that firm to develop my own little niche and book of business. And so I spend 100% of my time representing auto lenders across the United States. And we try to do things a little differently than what some other firms have done in the past. And it seems like the my clients like that. And we can talk a little bit more about that as we go. But yeah, that's where I spend my time. And I'm thrilled to be here with you again today. I'm a little passionate about what we do and how we do it and how we help our clients, which is what we all want to do, right?
Yeah, well, I mean, look, I can feel the energy, and definitely you are passionate about it. But before I ask you the first question about Replevin, you mentioned something that I think that our listeners should really notice is that in this space, even you come from one law firm, you go to another, it's not competitive in the way that other industries are. What I've noticed that lawyers in our space help other lawyers, help mentor them, bring them up, bring them in, and really celebrate other lawyers' successes.
Yeah, yeah, and we've talked about this a couple of times, right? I think we mentioned it briefly in the earlier coffee break. We at the NCBA Connect conference, we had a panel and we talked about it. What I think is great about Replevins is regardless of the size of the firm that a particular member of NCBA is in, or regardless of the market that they're in, right? I happen to live in a fairly large metropolitan area, but I grew up in a small town called Delaware, Ohio, about 20 minutes north of Columbus. And whether you're in a small town or whether you're in a larger market, there are companies that make car loans to people. And good, bad, or otherwise, every company that makes car loans to people has bad loans. Because if you don't have any bad loans, what's it say? You're not making the right amount of loans, right? So
Right.
if you follow the industry, defaults are starting to pick up. And so even the buy here, pay here lenders on the corner or a small community bank who decided to make some car loans, almost every city in America has a credit union of some size. All of those entities are potential clients for lawyers who can do replevins. And I think that's an important message that NCBA needs to continue to promote, that this is something that could be a service to any of our members, regardless of the size of the firm or where you practice. And it's something that is not the most difficult thing to do. And if most of you are already doing debt collection suits, then you could easily learn and do a replevin.
So you may have, kind of answered this question a little bit in what you just said, but Replevin's getting a lot of attention, and maybe you just told us why that is. But for creditors' rights attorneys, how can Replevin be a strategic part of their practice? Like, how could they add this on, and how would that look?
Well, the first thing any lawyer that wants to do replevin needs to do is learn the state process and the statutes, right? That's really important because they're all laid out. And as a matter of fact, in today's world, you could even get most of the forms online, right? But let's just assume you're trying to collect a credit card and you're filing a lawsuit to collect that credit card. You have to file a complaint. You have to serve people with that complaint. You have to take a judgment. And then you generally, if you're a collection attorney or a creditor rights attorney, you're going to file a garnishment or a bank attachment. You're going to do some type of execution after you have a judgment. Make sense?
Yeah,
So,
yeah.
so guess what? A replevin is just like that. We have to file complaints. You may or may not have to file a motion in your particular state to get an order for possession. Once you serve everyone, you can get the order or a judgment. And then once you have an order or a judgment, you issue a writ to the sheriff to ask the sheriff to go out and pick up the car. So there's an incredible amount of similarities between a replevin lawsuit and a debt collection lawsuit. And so that's one of the reasons why it's just another, for lack of a better description, tool in the toolkit of a creditor rights attorney that he can offer to some of his clients.
Now, how does the law firm, how do attorneys' fees work? I mean, it's, in general in debt collection, it's a contingency fee basis, huh? But
Yeah.
but what do you do? There's no money.
Great question. That's a
Um,
great question, right? And so, I grew up cutting my teeth, not necessarily doing replevins. I mean, I always did replevins, but I didn't really run a program, for lack of a better description, right? And I spent a lot of time in my earlier professional career, Nathan, in the mortgage default space. And I found in the mortgage default space two things. Consumers sometimes respond to letters from law firms when they don't respond to the actual lender. The second thing I learned from the mortgage default space is back at the height of the foreclosure crisis, when attorneys were filing a lot of foreclosures, a lot of regulators came in and said, hey, you can't charge $4,000 for a foreclosure when you file the complaint because you haven't performed the rest of the services. So, what I will tell you is what we do at my firm and what I've done for the last 5 years is I've worked with my clients and I bill the replevin in milestones. They're flat fees. And so, as I set up a file, I might bill a portion of the flat fee. When the complaint gets done, I might bill another portion of the flat fee. If the borrower surrenders the car at either of those two steps, I close my file and I'm done. If I have to issue the judgment and the writ, then I'll bill the last part of that fee. So I'm billing the client, and depending on the state, some states attorney fees are recoverable, some aren't. In Ohio, where I live and primarily practice, they aren't. So it's really important to be able to the lender to only pay for the services that you perform because some are recoverable and some aren't. And even if they're recoverable, we talked about this earlier. They're really just focusing on the collateral and not necessarily the balance. So by billing in milestones, you're helping your client and you're helping the consumer. But
yeah, no.
regardless, it's not contingent. It's generally a flat fee.
Okay, so
Make
so
sense?
in a way, yeah. So in a way, it is actually a revenue generator for
Without a
a
doubt.
firm,
Without a doubt.
because you're going to get paid on every file something.
Yeah, great point. Yes, for sure. For
Right.
sure.
So let's talk about tactics. What are the key considerations that, a law firm, if you're managing a law firm or you're a partner in a law firm, what would be those considerations to build a replevin practice? Like, what would be the tactics? What would you do to get started?
That's you have got some great questions today. You are on it. So here's what I would tell you. The first thing you need to do is talk to your clients. Talk to the people that you're going to build the practice around and see what they want, right? So I've been very fortunate that we've built our practice around communication strategies. I have always taken the attitude, Nathan, that if I can help an auto lender prevent one or two replevins of any 10 they refer to me, if they have a choice in the market who they're going to refer work to, they're going to refer it to the firms who help prevent the replevins. That makes sense?
Yeah.
So we're now working with our clients. When they refer a file to me, the client is emailing their borrower saying, hey, we just referred this account to outside counsel, but call us and work it out. And so I may send one or two letters and the client says, hey, close your file. And so I get to bill X, and all I've really done is send a couple of letters. Like, pretty profitable process, right? And so what I would tell law firms that want to get into this space is sit down with the clients that you're going to represent and try to create some strategies around not just the litigation process, but the workout process, because that's really important. And that's where you're going to get the huge benefit to the client. A little short-sighted, right? Because a lot of lawyers are like, I get paid to file replevins. I want to file replevins. I'm suggesting that you might get more replevins if you help the client create more workout opportunities.
Yeah. And also, clients definitely, pay attention to consumer complaints, consumers, going to regulators. So having an appropriate workout arrangement or a way that the consumer can feel listened to and treated, respectfully is also going to get you more business.
Yeah. And for those who may have been at NCBA Connect, or, we had a panel and there was a lender on that panel, a large regional national financial institution, and they stressed that they're looking. Here's what I would tell everybody who's watching today: try to not be your client's legal partner, try to be your client's business partner. Because if you can be their business partner and you can earn their trust, then you're going to get a lot more work that way than just being a traditional legal partner. And I feel like, Nathan, that's been one of my strengths. Is I tell my clients day one, I want to be your business partner, not your legal partner. And then I do things so that they do that. And for people who are successful in life, it's not a difficult formula. People like to do business with people they like and trust. And so if you tell your client, these are the things that I want to do, so maybe you don't get billed all the time and your consumers get more workouts. And we haven't even touched impounds, which is a really near and dear space to my heart, where you're getting cars back from repair shops and tow lots. That's the kind of stuff that clients really like. Educate your clients, right? Sit down with the people that are referring you Replevins and walk them through the process. Tell them what it's like. Tell them what they expect. That's the kind of things that earn you the respect and the trust as a business partner, not a legal partner. And that's the message I would send to every partner who runs any creditor rights law firm, or actually, in all honesty, any law firm in the country.
Yeah.
Money doesn't
That's
lead, money follows. And so if you earn
yeah.
that trust, you'll be in a much better position.
Yeah.
Sorry,
So
I kind of
no,
preached a little bit there.
no, I think that's great advice, and it's so true. When you're short-sighted, and that kind of leads to my next question. I think we may have kind of touched on the answer already. Should attorneys that are doing Replevin file for possession only, or also for a money judgment, and why does speed matter? So, I think we kind of touched on the answers to this, but
Yeah,
what do you
that's a
think?
great question, right? So in most states, you have the opportunity to file a replevin, meaning asking the court to give you back the car, by just asking for possession or asking for possession and a money judgment. And I'm going to quote Tom Canary, our president, right? Tom loves to tell the story that, he walked into court and the judge said, "What are we here about?" And Tom said, "Judge, we're here to just get possession of the car. My client's not getting paid. They're entitled to possession." And the judge looked at the defendant who showed up and he goes, "Are you making your payments?" "No, sir, judge." Are you able to get current?" "No, sir, judge." "Do they have a right to this car?" "Yes, sir, judge." And the judge goes, "Mr. Canary, you get the car." And so, based on today's environment, some of the stuff we talked about, Nathan, in the first coffee break, and I'll just quickly mention it here. Today, I think clients are focused on getting that asset back as quick as possible for a couple of reasons, right? It's a depreciating asset, number one. Number two, they realize their best opportunity to recover and maximize their recoveries are to get the collateral back. Number three, all of these are used cars once somebody has it, right? With new car prices at $50,000, the average new car price at $50,000, people need more affordable cars. So by being able to get that car back as quickly as possible for your client, and maybe that's because we're focusing on just getting the car and not the money balance or the money judgment or the rest of it, a court's going to give you an order for possession much more quickly. And that allows the client to get it, sell it, and maximize their recovery, because it's now a used car that they're selling at an auction that a dealer can then put on his lot. So it's all kind of tied to the industry. But again, sit down with your client, make sure they understand both processes, make sure you're understanding what they want, right? Maybe not treat a $20,000 car the same as a $100,000 car, because car values are different and the client's expectations and needs may be very different.
Yeah, no, definitely. And used cars do retain their value much, better than they used to, so that
Yeah,
it's actually worth something. I mean,
without a doubt.
I kind of used to get it why they would let it sit, because, it's a lot of work. It would cost almost as much to process to do the whole repossession or replevin, depending on the
Right.
state of the account, then the money you'll get. But that's changed drastically.
We've talked about the advantages of being at NCBA Connect, right? And I was with someone at NCBA Connect that was the top 5 auto lender in the US. They're not my client, but We've had some conversations, and they said, Frank, for the first time ever, we are thinking about just getting possession of the car in the legal process and not the deficiency judgment, because our experience has been that we can get them sooner in the legal process if we don't ask someone to agree to a money judgment or take a money judgment. I'm of the opinion, Nathan, that one of the strategies you could do is, if you're going to sue for possession and the money judgment, if someone voluntarily surrenders the car, ask your client for permission in states where you can do it to dismiss that lawsuit without prejudice. Once the client's got the car back, they still have a right to file a suit, depending on what the future has, to collect the deficiency. There's some states you may not be able to file twice. That's a different issue. But if it's a state that you can dismiss once you have the collateral back and maybe pursue a money judgment later, and that gets the client the car much more quickly because it makes the consumer feel good about it, maybe that's the best strategy.
Yeah, and also you might actually retain a customer,
You might.
people get back on their feet, I don't think they may remember, that you only took the car and they want to keep that relationship. So I think there's a reputational issue, a reputational risk issue also in the way creditors handle that. But let's talk about some legal nuances and industry challenges. What are some of the hot topics in auto lending right now? And then the second part of my question, which is, I know you've been waiting for a minute to get there. Tow lots, tow lots, repair shop impounds, lien strips. How do these affect the consumers and the lenders?
Yeah,
So,
those are all the hot topics. If you, I mean, always it's always about getting back their collateral, right? And traditionally and historically, Nathan, it's been a consumer who doesn't want to give the car up, and that's been an auto lender's biggest pain points. Some of what's going on in the industry today is, for whatever reason, we'll talk about them in kind of in any order, but the first thing I'll talk about is lien strips. And you're going to, well, Frank, what's a lien strip? Well, through no fault of the auto lender, their lien on the title is being stripped. And I'll give you some examples. I had a client that loaned money on a $70,000 Lexus to a dealership in California, the dealership's customer, right? 2 months later, they are looking, because they're not getting paid, and because it's a 60-day high balance loan, they're looking at them much more closely, right? And they run a lien check and they see that their lien was stripped in the state of Alaska.
hmm,
Very odd, right? And
yeah,
then they look a little further and they see that this vehicle that had the lien stripped in Alaska got sold at an online auction out of Texas to a different Lexus dealership in California. The car
huh,
probably never left California, but somehow, some way, a very sophisticated individual or group of individuals somehow were able to strip the lien in Alaska. They then, at that point, got the title to the car, agreed to find an online auction who then sold it. And basically, it's a new white collar crime that's out of control. So, what I would tell you is, they just took $70,000 out of the pocket of our client. If someone would rob a bank of $70,000, the authorities would be all over it, because this is white collar crime. It's an issue that hasn't gotten the awareness that it needs. But for those of us that are doing regional work, national work, not necessarily the local work, lien strips are becoming a very, very hot topic, and it's costing our industry millions of dollars. And when I say our industry, I mean the lenders. And as we all know, the cost of credit, right, is affected by the losses in a portfolio. So we are trying very hard to raise the awareness of this issue. I can tell you, I was at a conference last week and happened to be lucky and have breakfast next to in-house counsel of one of the captive auto lenders. And when I say a captive auto lenders, they lend primarily to the manufacturer customers, right? Whether it's Ford or whoever it is, right? That's just to give you an idea. And it wasn't Ford, full disclosure, right? But
right.
lien strips are an important issue across the industry. So be aware of it. And it's crazy how it happens. If you've never pulled a Carfax before and you're in this industry, they maybe cost 16 or 18 bucks. It's an invaluable tool to see the history of a title to a car. So that's one hot topic. The other hot
Yeah.
topic, which is very near and dear to my heart, which is a very state specific issue, is repair shop fraud and tow lots not necessarily fraud, who ask the lender to pay money for a car that they have towed and stored. And so traditionally, Nathan, the repair shops and the tow lots have sent these outrageous bills and invoices to lenders to say, hey, you owe me $20,000 for this car. If you don't pay me, I'm going to sell it. And you and I have talked about maybe NCBA and their lobby getting more involved in some of these state level issues, because what the industry has done is when they get these invoices, they go, oh my gosh, $20,000. This car might only be worth 30. I can't pay 20 for a $30,000 car. So they don't pursue it. And the lot or the repair shop sells the car. Well, the industry thinks, well, you're an auto lender. It's not a big deal. You can sustain a $30,000 loss. What they don't understand is the individual borrower didn't have that car repossessed and sold by the lender. So the deficiency wasn't reduced. And now the borrower is on the hook for the entire balance. That doesn't hurt the lender, that hurts the consumer. And so, I have a long list of some successes and horror stories where a repair shop says, hey, I did $20,000 in repairs, of which $12,000 were parts. And so I said, well, send me all of the receipts from the parts that you purchased and send me proof that you purchased the parts. And when you start to ask those questions, the lot will come back and go, oh, well, I got them from my salvage yard, but that's really what they cost if I bought them on the market. Because no one questions the bills. And if you don't question the bills, then you're either one of two things are going to happen. You're either the lender's going to pay too much for the car, or they're going to just walk away. And again, both of those things hurt the consumer. And then back to the tow shops and the tow lots, there are state statutes that come into play in most states as to notice and when notices have to be sent, and who those notices have to go to. So individuals who want to get into this Replevin space, Nathan, that we've talked about and that it's easy to get into, study your state statutes about what are the requirements of repair shops and tow lots. Because again, whether you represent a state, an entire statewide practice, or a local practice, those impound, those repair shop, those tow lot issues are right in your backyard. And you've got a great opportunity to advise your clients, make and get some great results for them, and save them money. And all of that is generally billable hourly work that you're doing. So
Yeah.
another little niche practice that you can just walk into.
No, but what I really was hearing is that there's room and opportunities for legislation at the state level that is not only benefiting the creditor or the company, the manufacturer, but really consumer protection type of safeguards that are
Yeah,
just not that are failing consumers today. In other words, you have criminals in essence stripping liens, right? That's should be. I
that's
mean,
right.
if it's not a crime, it should be a crime, and it could be that it is a crime, but the way it's defined in the statute doesn't align with what's going on here. So
Or it's not, or there's no statute at all. Nathan, there are actually states, there are some states in this country that actually allow a repair shop or a tow lot to sell a vehicle without ever notifying the person who has a lien on the title. Think about that. Like, we are
I
a
mean,
country,
how's that possible?
we're a country of due process, right?
Right,
And you
right.
clearly have a property right in a car if you have a lien on the title, but yet this particular state doesn't even require a notice. It's
Yeah, and
insane.
it doesn't make so having a criminal statute that has enhanced penalties, if it's someone who, because usually if you're doing this once, you're in the business of doing this crime, right?
There,
So there should be saying enhanced penalties if there's a scheme, or you can show that this is it's not a one-off. The guy's in business
yeah.
to do these
Yeah,
kinds of crimes.
but the counter of that is there are some very reputable repair shops and tow lots, right? And so I had a case for a client with a very reputable dealership in Northern Ohio, but they were asking for storage. I immediately said, we're not going to pay storage, but you did repairs. If you did the repairs and you did them properly, my client will pay you for that because that adds to the resale value of the car, right? They said fine. They sent us all of their invoices. They sent us that they paid for these parts. They allowed my client to inspect the car. But one of the things I said to the attorney for the dealership, I said, look, we're not going to pay 80% markup on these parts. Like the customer could pay that, but my client's a lender. They've already suffered a loss. Cut me some slack. I'll pay you the cost of the parts. We'll pay for the repairs. We'll give you your reasonable hourly rate of labor. And the client cut a $20,000 bill down to eight on a $30,000 car. And they built, and I billed them a couple of $1,000s. It's a huge win, right? But that's the level of detail that you have to have if
Mhm.
you're going to do this kind of work. You trust no one, sadly, because the
Yeah,
ones you
well,
trust are the ones the client works out and they don't need the lawyers for.
I mean, to me, this seems very parallel to, you know, as time has gone on across the country, in almost all states, there's some level of documentation that needs to be attached to especially an assigned debt uh, lawsuit.
Yeah,
You have to attach the charge-off statement, use statement, the bill of sale, the assignment, the
everything,
affidavit,
everything.
everything,
Yeah.
right? But here you're telling me is a situation where the literally the people that are being taken advantage of are the consumers. It's not like, well, some places maybe don't want to protect the creditor or whatever. It's a big company, like you said, they could absorb the loss. But here we're talking about really taking money out of people's pockets, and even worse than that, if it's a scam, you've and that person needed that car to go to work, or pick up kids from daycare or whatever. Um, there ought to be a law. I think we should work on that.
Well, and I agree with you because again, I think the industry is partially at fault, but it's really something that hurts the consumer at the end of the day. And when you talk about the amount of money that either the lender is losing because they're not getting the cars or they're overpaying for it, it's substantial. It's substantial across the industry. And again, it's a multi-million dollar, multi-state problem.
Yeah, and I'm hoping like the FBI or there because I'm sure as we're speaking these type if it works that lien stripping scheme, then the criminals are pretty smart and they're all over it, and it's got to be a much like it could be probably a multi-million-dollar kind of operation across the country.
So here's what I would tell you, right? I'm working on it. I'm very fortunate. I sometimes it's better to have friends in the right places, right? So we've gotten the attention of a U.S. senator on this lien strip issue. There's an entity inside the department, the U.S. Department of Justice, that sends out some notifications, but I don't think they send out the right notifications with the right level of detail. And so I hope when the government shutdown is over, that we get in front of that entity that's inside the Department of Justice and can get some help on the lien strip issue. And you know what? Make sure you stay in touch with NCBA because I'm sure we'll be on top of that issue because that's what we want to do, right?
Yeah, no, that is something we want to work on, and uh, especially when there's an issue that helps all facets of the industry, the consumer
Without a
and the
doubt.
creditor, then
Yeah.
then it's a no-brainer that
And the
it's
consumer.
something to work on.
Yeah.
And
And the
right, yeah,
consumer.
I'm saying
Yeah.
and the consumer, yeah, and definitely look when people talk to me about this industry, I always say, regardless of which side of this uh, adversarial relationship sometimes that we're representing, we're all consumers. I'm a consumer, you're a consumer, and our family are consumers. We want everyone that is involved in borrowing and lending and repaying be treated with respect,
Yeah.
treated appropriately. So it's
And
not
fairly. And fairly.
fairly
Right? Yeah.
and
Yeah.
fairly, yeah. So I'm
Yeah.
saying it's not as if we people that in this industry just care about the bank, so to speak, and the heck with the rest of it, because we understand that that is not maybe how you move this industry forward, and definitely not how it's done appropriately. You could, I always say to people, it's not just one case. So when you may not handle a case properly in court, you're going to be back in front of that judge again. You're going to be dealing with
Yeah.
the other side again.
Yeah.
Doing things right is the way you sustain a industry like this. And as attorneys, you shouldn't want to do it any other way anyway. You know?
Yeah, without a doubt. And I think back to your comment, I think the key is fairness, right? We want fairness and we want fairness across the industry. So people shouldn't look at auto lenders as a deep pocket. They should look as a party who is harmed. And if the lender is harmed, ultimately the consumer is harmed. And so again, the industry hasn't done a very good job of telling the story of the repercussions and the consequences with repair shops and tow lots. And I think that's a story that needs to be told. And it really primarily needs to be told at the state level, where some of these laws just either don't exist or need to change. And listen, I want people to get paid for what they're owed, right? If a tow lot performs a service, they should get paid for that. If a repair shop does repairs, they should pay for that, right? They should be paid, but they
Yeah.
shouldn't be paid for a $20,000 tow bill and repair bill and storage for $400 a day, especially if you have like the most recent case I had, a shop had a car for 4.5 years and never sent a notice to my client. And the first notice to the client was from a lawyer, I want $65,000 in storage. I'm like, come on, really? You had this car for 4.5 years and you never even told my client about it? And then Nathan, the woman, the attorney said, but we performed a service for your client. We stored this car for 4.5 years. And what she didn't realize is the car did nothing but significantly depreciate in value the entire 4 years. And then she said, we did repairs. And I said, okay, let my client inspect the repairs. She goes, well, it was transmission. I said, okay, then let your guy drive it around the lot so we can see that it works, right? She goes, well, it doesn't work anymore and we don't have a key. I'm like, well, then how'd you repair the transmission in the first place? So just some simple common sense goes a long, long way. But I'm sure this attorney never had been questioned about what was the repair bill and can we start it and drive it, on your lot, of course, right? So
Yeah.
just simple common sense goes a long way. But for that consumer, right, that consumer is being taken advantage of.
Absolutely. And look, it was never meant to be a windfall, right?
Right.
All right. Well, look, we're getting close to the end of our cup of coffee here, and got to kind of wrap it up. So this has been a great second part to a two-part series. We've talked a lot about Replevin. There's so much here. What can our listeners look forward to NCBA getting involved in down the road? What kind of things should
Great.
our listeners be
You know what?
looking out for?
That's a great question, Nathan. And I may or may not be the person to ask it of. I think Tom Canary has asked me to be more involved in the Replevin initiative that is near and dear to him, to his heart, right? Tom's specialty has always been recovery of collateral for clients. He sees the need, he sees where the industry is. I'm thrilled to be able to work closely with him to I don't want to say promote Replevin. What I will say is I think we would like NCBA to be a place that we can bring together lawyers and auto lenders, and then someone like you who is as passionate about this industry and how we can help them under one big umbrella and one big tent. And there's room, as we've talked about, for everybody. The small solo practitioner in the little city, and yet the bigger regional firms and national creditors and local creditors. And if we can bring everybody and all of those parties under one big tent, for lack of a better description, and we can start to advocate for some of these things that we talked about in some of the states that aren't very fair to the auto lenders, then it's a win for everybody. And most importantly, it's a win for the consumer, right? It would be great if we could get the regulators whose focus is treating consumers fairly to be engaged in repair shops and tow lots. And it's a challenge right now. It's a big challenge. And so I think that's what our mission is. I think that's what Tom would like the mission to be. And so that's what I would tell you, to stay tuned and not just listen, but getting, I think I said this in the last one, get engaged. You can get so much more out of an organization like NCBA if you contribute to it. So we need you, we want you, and we'd love to have you. How's that?
That sounds great, Frank. And you put it as clearly as it could be. You get out of it what you put into it. And if you're looking for business, shying away from being at a conference, shying away from talking to peers, talking to colleagues, that's not how you're going to get business.
Yeah.
Because I can tell you, the most successful attorney is not always the smartest attorney, and the smartest attorney isn't always the most successful. A lot of it is about your business acumen and thinking about things from a networking perspective.
So if I've totally forgot something that I probably should have added a long time ago. At NCBA, Nathan, I run a national network of law firms. I manage them for national auto lenders. At NCBA, I had an opened forum for law firms to come in and talk to me or ask me questions about, would you like to join my network and would you like to do Replevins? And so I totally forgot about that, which is crazy, but That's what else happens at NCBA. There are large creditors that are there that are willing to interview firms to see if they would be a good fit. And I was one of those. And I need good firms in states. So gosh, I totally forgot about that, and that's my bad, but that's that adds to the just another example of why you want to be an NCBA and why you want to go to conferences.
Yeah, I mean that. So people came without a client, may have left with a client, and that's really
Yeah, I think I
makes the
had
whole conference.
Nathan, I think I had maybe 30 firms show up.
Wow, that's
Yeah.
fantastic.
It
That's
was
great.
fantastic. It was
No, it
fantastic.
really is. All right, well, our time is up. Frank, this has been a fantastic two-part conversation. Thanks again for joining us. And to our listeners, thank you to all of you for joining us for this coffee break. Please subscribe, stay curious, stay engaged, and
I like that.
stay caffeinated. Until next time, I'm Nathan Willner. This is NCBA Coffee Break, and thank you again, Frank. This was fantastic. Have a
Thanks,
great day,
Nathan. I've
everyone.
enjoyed it and I appreciate it very much.
Thank you.